Hello everyone and welcome back to our video newsletter. In this video I want to talk to you about why you do not want to file a Baker Act. What you really want to file is a Marchman Act or a guardianship or a bit of both. So we get calls all the time from families who want us to file a Baker Act on their behalf to Baker Act a loved one into a facility. And I typically tell them, no, I'm not going to do that. If it's an emergency, you need to call 911 and ask the police to come out there along with the emergency medical technicians and let them decide if a Baker Act is appropriate. Because the Baker Act is not a treatment statute. It is designed only for emergency stabilization only. And I've talked about, the pluses and minuses of the Baker Act, in many of the videos that you'll find on our website and online. And so I'm typically going to say, I'm not filing a Baker Act for you. If it's an emergency, call 911. But what families are really trying to do when they call us most of the time is they're trying to get the loved one into treatment and they want to get them help. And I totally understand that. So let's talk about what really should be considered as options. Number one is the Marchman Act. The Marchman Act is Florida's involuntary commitment statute for substance use and co-occurring mental illness. So if your loved one has a substance use disorder and they may or may not have a mental health issue going on too, typically they do, they go hand in hand, then we can talk about doing a Marchman Act, okay? And that is probably a much more gentler way of doing things than filing for a Baker Act or getting the police to Baker Act your loved one. The other option is a guardianship. So Audra Simovich, who's my partner here in the law office, she handles all the guardianship cases in the office. She's the best guardianship lawyer I know. And those cases are typically done when we're dealing with somebody who has primary mental illness, or maybe they only have mental illness. Perhaps there's significant issues of anxiety, depression, schizophrenia. Eating disorders are great cases for a guardianship. And a guardianship will give you a whole lot more control than a Marchman Act. So a Marchman Act is designed specifically to give your loved one the ability to go get treatment and give you the ability to make that decision for them. The guardianship can give you the ability to make treatment decisions for them, but it also gives you the ability to control finances, have access to their medical records, and control other parts of their life. So it's more of a hammer than, perhaps sort of a surgical tool, like a scalpel. So, those are other options that you should consider. Now, is there a time when the Baker Act sort of might, become part of, either a Marchman Act or a guardianship? The answer to that is yes. There have been times where we've done a Marchman Act or a guardianship, and in the middle of the process, the person becomes so destabilized that it's necessary for a clinician to initiate a Baker Act. Again, to initiate an emergency stabilization procedure. Does that mean that the guardianship is over or the Marchman Act is over? No. It just means that there's sort of a crisis, situation going on here, and we need to address it. And we rely on the clinician at one of the facilities to make that decision for us and to initiate a Baker Act. And so look, none of these things are set in stone. And what I mean by that is when you're dealing with somebody who has substance use or mental illness or both, there are times when, the lines get blurred. And I understand that is a traumatic situation for a family and the situation is fluid. But as a general rule, if you want to get your loved one into treatment, unless it is an emergency, you do not want to do a Baker Act. You need to consider Marchman Act or guardianship, or sometimes we do a little bit of both together. And I'd be more than happy to discuss how the two of those things can work together. With that said, stay safe and be well.